Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about Alberta's Bill 211. That's titled the Municipal Government Firearms Amendment Act of 2020. What this bill aims to do is to restrict the ability of municipalities to pass bylaws around firearms. Now you might be wondering, why would they want to do that? Well, this is a pretty direct response to Bill C-21, which proposes to allow municipalities to pass bylaws against handguns that would then have criminal effect. So the response from the Alberta government is to then take some power away from municipalities so they can't actually do that. Now you might be saying, wait a minute, how does this work constitutionally? Because there's a division of powers. Don't the municipalities have their own powers? And the answer is not really. The Constitution sort of envisions a federal government and a provincial government, but municipalities are then in turn created by actions of the provincial government. So municipalities aren't really their own thing. They're kind of an extension of provincial power. And this makes good sense because if you're thinking, the Alberta government doesn't really want to get into the day-to-day nitty-gritty management of Fort McMurray and Edmonton and Calgary and smaller towns. They don't really feel that they're the best place to decide what the maximum and minimum fence heights are for Fort McMurray, for instance, or, what kind of lawn mowing you have to do. That's really something that needs to be very, very local. So that's why municipal governments sort of exist, is to take that burden off of the provincial government, but they don't really have their own sets of powers. They're given powers through the Municipal Government Act. So let's have a look at this bill here, because this is kind of an interesting response to a bit of a constitutional fight. The federal government wants to bypass the provinces in order to give this power directly to the municipalities. And at least here in Alberta, the province is saying, no, that power belongs to us. You can't cut us out of the loop here. So let's have a look at this bill. If you're thinking, oh good, we're going to go through a whole long bit of legislation, I'm here to disappoint you, because this one's actually fairly short, but it is a little complicated because it's in 3 different documents, more or less. So let's have a look first at the bill itself. So Bill 211, and this is it. There's not a whole lot to it here. So 1, the Municipal Government Act is amended by this act, so it just tells us what it's changing. 2, Section 74 is repealed and the following is substituted. And it says, firearms, despite any other provision of this act or another act, a council may not, unless authorized by the Lieutenant Governor and Council, pass a bylaw respecting firearms. 3, this act comes into force on proclamation. All right, so that's really short and basically just says they can't pass a bylaw. However, there's more to it than that because there were a whole bunch of amendments that went in and that were agreed to. So we have to look at those as well because they will actually substantially change what that bylaw says. So amendments to Bill 211, Municipal Government Firearms Amendment Act 2020. Section 2 is amended A by striking out Section 74 is repealed and the following is substituted. And substituting, the following is added after Section 74. So what this particular amendment means is that they're no longer getting rid of Section 74. We're going to have to actually look at what Section 74 says because it will still be part of the law. And then it says by renumbering the proposed Section 74 as Section 74.1 sub 1. So the bit we just read is now going to be added on after Section 74. It's a subcategory. And in the proposed Section 74.1 sub 1, they're going to make a bunch of little language changes. First, by striking out despite any other provision of this act or another act, and substituting subject to subsections 3 and 4. Second, by striking out authorized and substituting approved. So where we see here that it said unless authorized by the Lieutenant Governor, it'll be unless approved by the Lieutenant Governor. That sort of sounds like it's less of a, it's less that they have to come and get permission beforehand, and instead the Lieutenant Governor can approve it after they go ahead. By striking out pass and substituting bring into force. So again, the difference between passing and bringing into force, you can pass a bylaw that doesn't yet come into force. So what we see here is essentially that this is a bit of a change and allows for a little bit of dialogue between the municipalities and the provinces. They can say, listen, we want, we've passed this bylaw. Now will you please approve it, province? Which seems like it makes sense. It makes sense that that the municipalities can propose a bylaw and then say, is this okay? Is this good? And the lieutenant governor can say, yes, we like it, approved, or else, no, we don't, and it'll never come into force. So that's kind of how that is designed to function now. And by adding the following after the proposed subsection 74.1 sub 1, which is a sub 2 section, subsection 1 applies to a proposed amendment respecting firearms to a bylaw that comes into force on or after the coming into force of this section. And B, a new bylaw coming or respecting firearms proposed by a council after the coming into force of this section. Why would they put this in? Well, because the original version might have actually canceled out every single firearm-related bylaw that already exists, and I don't think that they wanted to do that, because a lot of municipalities have, for instance, restrictions on firearms being discharged within city limits. So they said, well, maybe we don't actually want to cancel those. Maybe we want to keep those in effect. So they changed this to all future bylaws. And then subsection 1, does not apply to a bylaw respecting firearms that is in force on or before the coming into force of this section. And this section does not apply to a bylaw to be approved in accordance with section 74. So basically they're adding all of this to say, we don't want to cancel any of the existing bylaws. That's not what we're here to do. Those can still stay in effect. All we're trying to do is limit future bylaws. And in particular, they want to limit those future bylaws that might be aimed, at C21. So that's really what they're aimed at here. Now you might be saying, wait a minute, if they're not repealing section 74 of the act, don't we need to know what that is? And absolutely we do. So let's go and have a look at that right now. So firearms. A bylaw of a municipal district prohibiting in all or part of the municipal district the shooting or use of a firearm or other device that propels a projectile does not come into force until the bylaw has been approved by the minister responsible for the Wildlife Act. So this is already a limitation clause. It basically says that if they want to ban use of firearms in an area, they've got to get approval from whoever it is who's handling the Wildlife Act at that particular time. So that is, that's kind of an interesting provision because Alberta has a lot of hunting. Alberta has a lot of wilderness activity. In fact, I would say Canada in general does. Canada as a society, we place a lot of value on sort of our wilderness areas and activities that take place within them. So they basically, that's a limitation on that. They have to ask for permission for that. But that simply says shooting or use of firearm within the municipal district. The reason why they needed to broaden that, because really when we look at the new section here, it says simply respecting firearms. So anything about firearms at all. The reason why they needed to broaden that is because C21 is proposing restrictions respecting the storage of firearms and the transport of firearms and those sorts of things. So this, I think, is a really interesting example of sort of government dialogue, because you've got the federal government saying, hey, listen, we're going to give the municipalities these powers. And the Alberta government is saying, nah, we want to keep those. We are the provincial government. You don't get to bypass us and start making the municipalities into things that have powers that we're not in control of. I don't think that there's many provincial governments that will like the idea of municipalities being given powers that they, as the provincial government, don't get to say yes or no to, or that sort of attempt to bypass them. As an example, Quebec has already voiced some displeasure with the Bill C-21 framework. This is not surprising. Quebec has been very traditionally protective of its provincial powers and not wanting the federal government to meddle within its affairs. Bill C-21 seems to be a form of meddling. It's kind of intended to cut the provincial governments out of the discussion. So that's not going to be something they'll appreciate. We may see other provinces as well, because, the provinces typically want to guard their power in the same way that the federal government wants to guard its own power. So we'll have to see what happens with this, but we may see other provinces adopting something similar, or we may not. We'll have to see what goes on. In terms of whether or not I think this is a good idea, I think it's unfortunate that it was necessary, but I do think it is necessary. C-21 is really a bad bill in terms of creating a fractured set of criminal law within the country. The notion of somebody having to move out of their town because, their bylaw, we're really going to see neighbors turned against neighbors. We're going to see all sorts of problems with this. And so I don't like this proposal of basically having more than one criminal law within the country. I think that one of the great strengths of Canada as a country has been one consistent criminal law that applies no matter where you are within Canada. I don't know why anybody would want to undermine that. This one is interesting because it reflects a bit of the push and pull as you get different levels of government wanting to sort of fight for their degrees of power that they exercise. I could see potentially other provinces wanting to do something similar, not necessarily because they disagree with Bill C-21, but simply thinking prospectively, going, down the road, do I want the federal government to start putting more and more power on these municipalities, and what does that do for our level of control and our level of authority? So it'll be interesting to see if more provinces start to do something similar like this. I wonder if that might have an influence on the federal government and their proposals in C-21. I don't think Alberta on their own is going to carry a whole lot of weight there. I don't think Alberta's got sort of a strong voice within the federal government at this point. But we'll see. All of this is pure speculation at this stage. But this is a really interesting bill as it reflects kind of a pushback here. Anyway, thank you for watching. I want to encourage you to like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, BCAMF.org, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Matt Ward, Mike Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Adam Meester, and Marc-Olivier Damour, as well as a number of you at the $10 level in the crawl immediately following. Thank you once again for watching, and I hope this has armed you with knowledge.